Hi, this is Jim Cunningham. We're going to talk about pet trusts, your pet's care. We got you covered. You can do a pet trust. You can set up, at least in California, set aside money to provide for your pet. I'm going to tell you on a very high level, on the left is a pet, on the right is a wild animal. If you want to protect wild animals, you're not going to use a pet trust, you're going to do something else, and we'll talk about that. But if you want to protect your pet, and this is my dog Lola, she's a little rescue dog, and yes, she does tolerate outfits, right? So that was my daughter put the outfit on her. And, the little dogs are close to the ground. It's Christmas time. It's cold. She likes being by the fire. But pets need care. And sometimes if you're not around to care for your pet, a lot of people are concerned. Like they look at their pet as their child. They really love their pet. And people want to take care of their pet. So this hasn't always been the case. So back in the day, you couldn't do this, but now you can. And we're going to talk about that today. So I know I'm worried about who's going to take care of Lola, but when Lola dies, when I die, if my wife's not around and we have Lola, then our daughter would take care of her. So we kind of have that covered, and we made a provision for our pets in our estate plan. So kind of cool that we want to make sure that they're taking care of whatever pets that we have when we pass away. It's very important. California law does now permit you to set aside money for your pets, but who gets the money is in this case like the Lolas of the world. They really can't articulate their needs. They can't defend their rights. They can't enforce those rights. And so there's a mechanism for enforcement of the rights, frankly, of the pet. And we're going to cover how to make sure your wishes are carried out. And the money's just not taken from somebody who just, disregards everything. So it's very, very important that your wishes are carried out. And really, that's the primary focus of estate planning, is to make sure that your wishes are carried out when you're no longer able to articulate those wishes, either because you passed away or you've somehow become mentally incapacitated, and making sure that your wishes are carried out. So I'm an attorney. These are the attorneys in our law firm. We have office locations throughout the state of California, Northern and Southern California. And if you're watching this on YouTube, please subscribe to our YouTube channel. And we do release about a video every week or so. And so this will pop up in your feed. So a lot of great content about estate planning. I'm a lawyer. My lips are moving. Words are coming out of my mouth. I am not dispensing legal advice. So when I say you, there's no attorney-client relationship. But do understand that this is information only, and you really shouldn't do anything without consulting with a lawyer. So let's start with what is a trust. So a pet trust, right? It's not a pet will, it's a pet trust. What is a trust? Well, a trust, there are two big kinds of trust, and what we're really going to be talking about here primarily is the revocable trust. A revocable trust is like a bucket, right? It's a bucket with a handle. You put assets into that handle. The trustee holds onto the handle, and we see this as in a living trust. We see this a lot of other types of trust that might be within within the living trust. A Q-tip trust is within a living trust that is revocable while someone is alive. But then when somebody passes away, that living trust typically becomes irrevocable, and a Q-tip trust is an irrevocable trust that springs into being after a living trust, after the person who creates a living trust passes away. So this can be a little confusing to kind of wade through these terms, but I do want to just lay out that what we're talking about here is this is typically a provision that is going to be included in a living trust, not so much an irrevocable trust. So an irrevocable trust can't be amended after you've set up the trust. And that's where we talk about dynasty trust, spendthrift trust, certain types of special needs trust. We cover that in other webinars. But really where you're going to find these provisions is inside of your living trust. So if you're thinking to yourself, gee, I'd like to provide for my pets, then those provisions are found inside of your living trust, not an irrevocable trust. And again, there's a lot of different kinds of trusts. There's literally 31 flavors, like there are 31 flavors of ice cream, and we've picked the top 31. There are a lot of other trusts we're not going to talk about, but we are focusing primarily on the living trust. So again, it's a bucket with a handle. The trustee holds onto that handle while the trustee has the office of trustee. The bucket is the trust. The assets are what you put, your house, your stocks, your bonds, your mutual funds. Those go into the trust bucket. The trustee holds onto the handle. When that trustee stops serving as trustee, that bucket is passed to the successor trustee. So this is can be confusing for people who might be new to this, or even if you're not so new to it and maybe it's a refresher. When lawyers talk about a trustee, and we're going to talk about trustees a lot in this video, but when we talk about a trustee, we are talking about the person who is currently serving, who's like the captain of the ship in charge of this trust. A successor trustee is somebody who is named to serve after the current trustee. So if I have a living trust, Jim is the trustee of the trust, and I may appoint Bob as successor trustee of my living trust. Well, we identify Bob as successor trustee. So when I stop being trustee, that bucket passes to Bob. Bob then becomes a trustee, and that designation of successor falls away. So when you hear lawyers talking about trustee versus successor trustee, just know that the trustee is the person currently acting. The successor trustee is the kind of the future trustee. The benefits of a living trust include a huge benefit, staying out of probate. And remember, we cover this in other videos, but remember that probate is specifically designed to pay off your creditors, quite frankly. A living trust is designed primarily to benefit the beneficiaries, the people who get the goods, the stuff in the trust, and this would include your pet. And in my case, it includes Lola, right? Our little dog. So another protection a living trust can give is creditor protection for people who inherit from you. Not so much for you if you're the one creating the living trust. It's not going to give you creditor protection. And also this protects a future inheritance from divorce or predators. And certainly in the context of a pet trust, there are predators beyond the bald eagle we saw in the image there, who's, Lola might be lunch for a bald eagle, or maybe a snack, depending on the size of the bird. But seriously, this living trusts are much better than wills because there are predators out there, and there are people who want to take the money that's in a trust, and even if it's for a pet. And we'll talk about ways to make sure that those assets are protected from those predators. So what is a pet trust? So typically a pet trust is not a standalone trust. This is typically what we see as provisions inside of a living trust. So a person who sets up a living trust and they make a provision for a pet. Now, before 2009, there were no such thing as a pet trust. So I was a certified specialist in estate planning, and there were no pet trusts. We had to do workarounds. We had to say, well, I'm going to give my animals to this person, and I'm going to give this person a certain amount of money. But what happened around that just before 2009 is the state legislature said, look, this is kind of becoming a problem. People are filing actions in court. There's not clarity, and frankly, people want to provide for their pets. So this does make sense. Because people who leave money for their pets want to make sure that that money is provided for their pets. And it's very important. Pets cannot articulate their needs. I mean, they can give you the face to say, I'm thirsty or I'm hungry. They can that's what Lola does. She doesn't even whine or bark. She just looks at us like, where's my lunch or where's my dinner? But really, animals can't say, gee, this person's stealing from me or they're not taking care of me well. So there's a structure to make sure that the pet is taken care of, and we'll talk about that. So with a pet trust, you can name a caretaker. You can leave money to be used for the care of the pet and describe how the pet should be cared for. You can name a person to go to court to enforce the terms of the trust, because really, right, if you have a pet horse, that horse is not going to be able to articulate what their needs are, right, like any other animal. And then you can state what should be done with any money that's left over. So if money's set aside to care for the pet and then the pet passes away and there's money left over, you decide where that goes. Horses are actually a very interesting example. I grew up, my mother is a horsewoman. Now, for those of you who know what that is, you know what that is. And if you don't, it's a woman who just loves horses. Now, when I was a kid, I didn't like that so much, right? But we had a horse that was, I think he died at 33. So these animals can live a very, very long time. And people form a deep emotional bond, not only to animals, but specifically horses. In many instances, they form that bond. So taking care of a horse is not a cheap endeavor. It's an expensive endeavor. You're dedicating land, you're dedicating resources. There are actually places where you can retire horses to, but you have to pay. And this is sort of what we're talking about, is this sort of long-term care for these animals. So what is an animal? So this is a really interesting question. An animal, for our purposes here, so for a pet trust, is a domestic or pet animal for the a pet animal that you've created a trust for. So when you talk about pet trust, we talk about animals, dogs, cats, horses, tortoises, anything that's domesticated. What is not included is that bald eagle that I showed at the beginning. That is not a domesticated animal. So if you want to provide for the bald eagles of the world, you would look at not at a pet trust. So you can't say, I'm going to put a certain amount of money in trust to protect the bald eagles in Siskiyou County, right? That's not a pet trust because those aren't pets. you would be going through another charity that does, the bald eagle charity or whatever it might be. So that money would be directed, there would be a different structures where I'm going for that. So what we're talking about here are domesticated animals, and really a lot of different types of domesticated animals, but we exclude wild animals. So how much does it cost? This is on California on average. What is the cost of care for a pet? Well, it is not. It's not a small amount of money. And if you're watching this on YouTube, and you can see the video here, there's food, there's veterinary, there's miscellaneous, and the totals can be quite big. And you see the big expense item here is a horse. So anywhere from $2,000 or $3,000 a year, to $9,000 or $26,000 a year for a horse. So very, very, could be a very, very expensive endeavor. I had one client many years ago who dedicated her home, and I think she had maybe a 20-acre parcel of land, dedicated that for her horses, right? She had a herd of horses, and she wanted to dedicate that land and those funds for the horses, and we set up that estate plan for her. But I think it's important to kind of work a little bit backwards, like, how old are these pets that you have when you pass away? What is the cost of their care going to be in the future? And then if you want to fully fund their care, you would need to kind of do almost like a back of a napkin kind of math at a very minimum. And how much money should you put into a pet trust? So there's no minimum, there's no maximum. We are going to talk about some dollar amounts, and that has to do with enforcement of pet trusts. But you could put an unlimited amount of money into a pet trust. But again, it's going to be different for different types of animals. So what are the statutory requirements of a pet trust? Now, when I say pet trust, this might be your living trust, which is a bucket, and then you might have a little sub bucket or sub trust within your bucket. So you might have a trust that leaves your assets equally to your 3 children, but you might carve out a certain dollar amount for your pet trust. It could also be a percentage. So you could say, I'm going to leave 10% or 30% to each of my children, 10% to the pet trust. You could say, I'm going to leave $50,000 in a pet trust and the balance go to the kids. So there are really 2 ways of getting there: a certain dollar amount, which we call a pecuniary gift, or it could be what we call a residual gift, which is in the residue, and that's when we start talking percentages. So if you hear attorneys, if you meet with an attorney or you meet with an attorney in our firm and they throw out the word pecuniary, that means a dollar amount going into a pet trust versus a residual gift, which is typically expressed in the residue, which is a percentage. So the pet trust typically continues until no animal living on the date of the owner's death remains alive. That's typically the term of the trust. Now, the requirements of a pet trust are all amounts. So all amounts shall be used for the benefit of the animal and not the trustee. So if you say, gee, I'm going to leave a trust for my 3 children and my pets, and they'll all be beneficiaries, that really won't work. You're going to need to carve out a certain dollar amount for the pets rather than lumping them in with humans, so they get their own separate pet bucket of money, if you will. Now, upon termination of the trust, so when that pet passes away, the trustee distributes whatever's left over in that pet trust, that little sub bucket, right? If our trust is a living trust is a bucket, it's a sub bucket. To the extent there's any money not spent, when that trust terminates, then the money is distributed as provided in the pet trust, or if there's no provision, it's under the residuary clause of the owner's will or trust, and if not, then to the heirs. So this really is not something, and I'm going to say this another way, this is not something you want to do on your own, that you want to handwrite. You do want to consult with a lawyer, really a lawyer who specializes in estate planning. And again, we cover how to pick a lawyer in other videos on our YouTube page. But this is really important because you want to make sure that you say, okay, this $50,000 is going to be used for Lola, and if there's money left over when Lola dies, what happens to that money? Where does that money go? And we'll have an example on that. So, well, here's our example. Owen's Living Trust contains a pet trust that gives $50,000 to Tina as trustee to hold for the care of Rover. Tina must use the $50,000 for Rover's benefit, and when Rover dies, the leftovers go to Ben. So Ben, who's the beneficiary, Owen is the owner, Tina is the trustee, Rover's the dog. You can see where we're going with this. So pet trusts are part of California law. This is Probate Code Section 15212. And the little rule on here, so if you're a lawyer kind of learning about pet trusts, we get a lot of lawyers watching our videos, if the value of the assets in the trust does not exceed $40,000, okay, so if it's $40,000 or less, no filing, report, registration, periodic accounting, or separate maintenance of the funds or is required. So this is very important. So you don't necessarily have to have a separate account. You just have to set that money aside. Okay, if it's a smaller amount, but if it's 40,000 or over, then you're going to have a different set of requirements. So, of course, this is unless ordered by the probate court or required by the pet trust. I will say most trusts most pet trusts would say the trustee is to set aside this $40,000. Best practice is to put that in a separate bank account. The trustee would, when they conclude the administration of the trust, which is after typically somebody dies, they would say that, okay, that 50,000 is going to go into a separate account, and Tina would be the trustee of that trust for the benefit of Rover. And what that means is that 50,000, Tina would open a bank account and put that money into a bank account and then use those expenses for Rover from that account. So what are the roles in a pet trust? So who's doing what? Who ensures that Rover, in our example, is cared for? Any beneficiary named in the trust can make sure Rover's cared for. Well, this kind of makes sense. If Rover's the family dog, if Owen has a family and you know, Owen, maybe Ben is Owen's son, and Owen says, I want to set aside money that Tina's going to manage for Rover's benefit, it would make sense that Ben would say, like, well, wait a minute, I'm a beneficiary of the trust. I have a stake in the outcome. I'm going to have a say over the care of Rover. It could also be a person designated in the trust. Again, probably best practice to designate a person in the trust, meaning you should think about, if you have a pet trust, having a person assigned to look after the dog. Is that the trustee? Is it not the trustee? You know, is it the fox watching the hen house? I'll let you make that call, but a lot of times it is a third party. It could be the probate court. It could also be a role called the trust protector. So a trust protector, we cover this in other webinars, is a person who is not the trustee, who has power over the trust, but is not the trustee. So a trustee has to follow the terms of the trust and carry out the terms of the trust. A trust protector can change the terms of the trust in many respects, can also remove a trustee, maybe appoint a trustee if the trustee's going off the rails. So a trust protector is a person who has power of the trust but is not the trustee. We do not see this in every living trust. It's a rather sophisticated tool. We use this quite often in our law firm because I think it helps you stay out of probate court, right? So if your option is to go to probate court or have a trust protector, I'd take the trust protector route any day of the week. The other person who can ensure that Rover's cared for is any nonprofit charitable corporation that has as its principal activity the care of animals. That organization may, upon reasonable request, so they can't be a jerk. Well, I suppose they could be a jerk as long as it's reasonable. They can, upon reasonable request, inspect the animal, the premises where the animal is maintained, or the books and records of the trust. So again, any nonprofit, and you could just have a laundry list of your nonprofits out there. If they're aware of the existence of the trust, I mean, obviously they'd have to be aware of it, they essentially can inspect and make sure the terms of the trust are upheld. So what we have here, if you're watching this on video, is we have sort of a diagram. So let's say Owen says, I'm going to leave my entire estate. In this example, he's leaving his entire estate to Rover, and then Owen dies, and Tina is the trustee. So now Tina, this bucket that Owen used to have the handle with the bucket, is passed to Tina. Tina, who is the named successor trustee, that successor designation drops. Tina is now the trustee. She is holding that money for the benefit of Rover and uses that money during Rover's lifetime for the benefit of Rover the pet, the dog. And then when Rover passes away, the remaining assets Tina then distributes to Ben, who is the beneficiary. So in this instance, we have a trustee who's the person who's in charge of things. It's the human being with the heartbeat, the living person who's signing checks and making things happen. We have the pet who's Rover, and then we have the ultimate beneficiary who's Ben. So ultimate meaning last. The ultimate beneficiary is Ben after the death of Rover. So the property's held for the lifetime of the dog, remainder to Ben. And this used to not exist. So if you had set this up before 2009, there would have been no money for Rover. All the money would have gone to Ben. So California law has changed that, and really for the better for a lot of people who do set up these pet trusts. So a trustee has a duty to account. Well, what am I talking about? So the duty to account arises when the assets are over $40,000. And what is an accounting? So you get an accounting if you still get your bank statements every month, which, I still do because, I don't know, I'm of that generation. A bank statement starts with a beginning balance, and the bank shows all the money that came in and all the money that went out and what's left over. That bank statement is fundamentally an accounting. It's the same thing. So what you would do is Tina has a duty to say what the beginning balance was of the trust, and have a record for all the money that came in, all the money that went out. So Tina can't take a trip to Tahiti and blow the money, right? So all the money that came in, all the money that went out, and then the money that's left over, all those numbers have to add up. And that is an accounting fundamentally. So Tina must account to the people who inherit when the last pet dies. So Tina has a duty to account to Ben. Tina's got to provide this information to to Ben. Accounting is this sort of process of recording financial transactions, summarizing, analyzing, and reporting these transactions to Ben or to a court, to the beneficiary, who's the person who's inheriting after the death of Rover, again, or to any nonprofit charitable corporation that has as its principal activity the care of animals, and that has requested these accountings in writing. So a random third-party charitable organization, a charity, can demand an accounting. So this is where the trust protector role can come in. So sometimes a trust protector can discharge that duty, if the person's being unreasonable, or maybe account to a different institution. So getting a little bit in the weeds, but it's important to understand that these nonprofits do have a say because they do under statute. Okay. So trustees must follow the terms of the pet trust or else. So what if Tina uses the money to buy herself a trip to Tahiti? That is embezzlement. That's a crime. Owen can designate a person to enforce the trust. Should it be Ben? Should it be the remainder beneficiary? Maybe. Otherwise, a person can be appointed by the probate court. But again, others can step in. Any other beneficiary named in Owen's living trust. So maybe the money went to Ben and Ben's sister, Sarah. Maybe Ben or Sarah could enforce the terms of the trust. Any person interested in the welfare of Rover, or again, any nonprofit organization. Ben can reach out to a lawyer. How do you do this? How do you enforce the terms of the trust? Ben can reach out to a lawyer who can bring a probate court case to have Tina removed and for her to return the money she stole. So let's say she did go to Tahiti and stayed in the overwater bungalow for 3 months, ignoring Rover, spending all the money, having a great time. A probate court would say, Tina, you're removed, and we're ordering that you pay back all that money that you stole. Interestingly, a trust protector can be a substitute for the court and remove Tina. But the interesting thing is that a trust protector cannot compel Tina to return the money. So you can stop the bleeding, but you can't get the money back. So only a court can order Tina to give the money back. A trust protector can compel an accounting even if there's less than $40,000 in the pet trust. This is important. So if you set aside $25,000 and Ben says, I think somebody, or maybe a beneficiary says, hey, I think something's awry, the trust protector can compel that accounting. I would really consider using a trust protector with a pet trust. It makes a lot of sense as a practicing lawyer, because it tends to cut out the probate court. Again, if you're seeking payment back for money that somebody embezzled, you're going to have to go to court to get that. So trusts always need a trustee, even pet trusts. So there are 3 elements of a trust: a trustee, a corpus, meaning assets, and a beneficiary. In this case, the pet is the beneficiary, not traditionally a beneficiary, but California enacted that in 2009, as we discussed. So there must always be a trustee. If Tina dies, like, who's the trustee? Well, if Tina's serving as trustee, so Owen passes away, Tina becomes trustee, then Tina dies, we go to the person next in line on the trust. So it says if Tina's passed away, then maybe we have Margaret as the successor trustee after Tina. But if there's no person named, you either have to go to probate court, or if the trust protector has the power, the trust protector can name a new successor trustee who then grabs onto the bucket handle and becomes the trustee, and then drops that successor term. So the trust protector can name a trustee if there's a vacancy in the office of trustee. Now, when I say there must always be a trustee, there must always be an office of a trustee. Now, that can be vacant, but that office of trustee does need to be filled. Otherwise, you're going to have some problems and you will no longer have a trust. So very important that you have a trustee and that role be filled. So what are some pet trust alternatives? So if this all sounds a little daunting, it sounds like overkill. You're like, look, I just want my pets to be taken care of. I really don't want this accounting, and I don't want all these, these charities to be able to cause Tina problems. What are some alternatives? Well, one great alternative is the San Francisco SPCA. So I believe they were the first SPCA, one of the first, or if not the first, has what is called a SIDO program that gives you peace of mind about the fate of your pet. It's an adoption program with free medical care for 2 years. The adoption staff provides care and quick placement for pets, and they relay the medical history, food preferences, and other details important to the new adoptive family. So adopting a pet after somebody dies is really an alternative way to go. And there are some fees typically that are attached with this. And San Francisco is very transparent on their fees. San Francisco SPCA, you can go to their website and look at their fees. It also gives you a little bit of guidance on how much to leave a dollar amount if somebody's going to adopt your pet. So you may want to say like, oh, well, I would like to have my cat adopted by somebody, but you might want to have some money go with that just to help out the person who may not otherwise be able to afford taking care of a pet. And if you have pets, you know how much joy it can bring you. And you know, many people want pets, and sometimes people just simply don't have the money to care for them. So pet trusts are they're often incorporated into the terms of your living trust. Mindfulness about who will handle the money and who will make sure your pet is cared for properly. You really should think about that. Who's in charge of the money? Who's in charge of the pet? Really think this out and commit that to writing and put that in the trust document. Consider a trust protector. Okay, this is a person who can keep the trust and out of court. Also consider pet trust alternatives. If you're watching this on YouTube, please subscribe to our YouTube channel. Thank you for joining us. And we typically have questions, and I don't see any questions. So if you just keep watching this video, magically another video will roll right after this one, and we'll see you soon.